Omar, I'm going to make your introduction. Thank you for being our speaker today. So prior to attending law school, Omar was a commercial real estate banker for approximately 17 years. Omar assisted in financing projects in Nevada, California, Utah, Arizona, and Washington by analyzing projects and reviewing trust agreements, leases, syndication documents, and other loan-related documents. During the Great Recession, Omar had an opportunity to work as a special asset officer in the commercial real estate department of Regional Bank. As a special assets officer, apart from analyzing the financial side of the project, Omar got more involved in the risk assessment side of banking, during which time he was a constant communication with clients and attorneys to minimize losses. While Omar was successful in his previous career, he felt that his calling was more toward the legal side of banking and finance rather than sales, and attend the William S. Boyd School of Law. Following graduation from law school, Omar left banking to pursue a career as a transactional attorney. Following graduation from law school, Omar left the banking sector to pursue a career. Oh, I already said that, didn't I? No, wait, I didn't. Since that time, he has worked for national and regional firms where he represented clients in contract banking, real estate, and acquisition matters. In his time away from the office, Omar enjoys spending time with his family, traveling, and playing golf. His area of practice is business law, banking and finance law, real estate law, contract law, mergers and acquisitions, and corporate law. Thank you, Omar. I hope I did you justice with that.
Thank you. And I'm going to give you a brief explanation of what I do, because that was a lot of stuff. So I'm a transactional law attorney. What that means is that I'm the person you want to talk to before you set up a business entity, get into a contract, acquire capital assets or real property, or buy or sell a business. So that's, in a nutshell, what I do. I understand that a lot of people over here are thinking about opening up a business or have opened up a business, and they are looking for entities that are best suited for them. So what I want to do is, I don't know if I can share my screen or not. So what I'm going to do is I'm going to give you a brief introduction on corporate entities, and I will start off with some of the simple ones, which are basically the sole proprietorship and the general partnership. Sole proprietorship is the basic entity. When somebody thinks about starting a business, what they do is they start working on the business by themselves. They are the only person that's in control of everything that's being done in the business. So they maintain full control over the business. For this kind of entity, you do not have to have any formalities. All you need is a business license. There's no formal structure. This is all dependent on how you run your business. The entity is taxed on your personal tax returns. So basically, usually it's Schedule C. That's where they show up your business, and you get taxed based on the income or losses you show there. As far as liability is concerned, in a sole proprietorship, all your assets are up for grabs at that point, your personal assets. There is no liability. If something goes wrong in business, creditors can basically come after all the assets that you own. So that's what a sole proprietorship is. The second entity is an entity that happens by accident. What happens is two people start working together, and in a little while, or after a little period of time, they realize that they are working a business together. This kind of entity is pretty scary kind of entity, because there are no specific rules and regulations in this entity. Again, from a taxation standpoint, the entity usually is taxed on your personal tax returns. Each partner gets a portion of that income that's being generated, and usually there are two partners, so the income and losses are split half and half. And what happens to liability is that each partner in the general partnership is subject to the liability created by the other partner, meaning not only are you liable for your own liabilities, but also the liabilities caused by your partner. So it's a very risky kind of situation. You don't want to be in part of that. Under the general partnership or the partnership, there are two additional kinds of partnership. One is a limited partnership, and the other one is a limited liability partnership. Limited partnership used to be an entity that was in place prior to the LLC being created. So what a limited partnership is, basically you have a general partner that takes on all the liability, all the risk, and then you have a limited partner who usually joins in with equity. So if something goes wrong with the business, the limited partner only loses whatever they have invested in the business, whereas the general partner is open and exposed to all kinds of liability. The third type of entity that's found under this partnership is a limited liability partnership. What that is usually used for those entities that cannot qualify for for an LLC. And I'll give you an example of it. Our law firm in Nevada can be Mobile Law LLC, but in California, we cannot be an LLC. We have to a limited liability partnership. So in those kind of situations, what we had to do was create a limited liability partnership. That way we satisfy California and Nevada laws at the same time. So those are the options that you have on a limited liability partnership and a limited partnership. What you have is partnership agreements that dictate what each and every partner does. In a limited liability partnership, you are not liable for the liabilities of your partners. The partnership is, but you personally are not. So that's the good thing about it. In a limited liability partnership, you are required to sign up, register with the state. There is an incorporation process, and you do need a business license. There are somewhat rigid rules and regulations because for both those entities, there are rules and regulations on how the general partner and the limited liability partners would act. So you have partnership agreements that will dictate how you do business. Also, the IRS considers such entities as taxing entities, and the income or the losses that are generated by these partnerships are reflected on each partner's tax returns. And this is also a pass-through tax entity, which means the taxes on the incomes are passed through to you and you're responsible for those things. So in mostly when we see people starting off, we see people starting off with a sole proprietorship, but soon they realize that the sole proprietorship is not an official entity. To make their project or their venture more acceptable to investors, what they try to do is form a limited liability company. A limited liability company can be formed by a single individual. There's no member limit to it, meaning they can be one member or there can be 10,000 or 100,000 members, whatever it is. This has formalities. You have to have annual filings. You have to maintain a resident agent, and you need a business license. In Nevada, limited liability companies are not required to have operating agreements. But if you want to make your business look official, it is highly recommended that you have an operating agreement. And if you have partners, again, it's highly recommended that you have an operating agreement, because the operating agreement will dictate the role, the membership interest of each member, the percentage, profit and losses that can be distributed. All those things are part of the operating agreement. Plus, if it's a limited liability company, it can be member managed or it can be manager managed. So those also define the rules and regulations on how the entity can work. Also, in a limited liability company, what you have is you can issue different classes of membership interest. So when you try to attract investors, what you can do is you can have certain class of membership interest where you can give them a preferred return till their initial investment is paid off. So that's the good part of a limited liability company. The investors usually do not like this kind of an entity if you get to more sophisticated investors, because they have very little control over it. As I said, the limited liability company is mostly run by the operating agreement. The managers or the managing members can dictate how the company is being run. So it's a separate legal entity. This also has a pass-through component to it, where the income generated or losses generated by the entity are moved to or sent directly to each member's personal tax returns through a K-1. A limited liability company also has an option that it can be treated as a partnership or can be treated as a corporation or an S-corp. And there are some uses to that as being treated as S-corp, and I'll talk about it in the next section.
Hi, Omar. Sorry to interrupt. You have one question before we move too far away from the topic. Can you explain the difference between LLP and why it's required in California but not in Nevada?
That's just California rules and regulations. They recognize a limited liability partnership for professional corporations, and they don't allow a limited liability company to run that through that. So doctors, attorneys, those kind of things are required to have a limited liability partnership. A limited liability company, as it sounds, it says that it can limit your liability, but that's a misnomer. Because what happens is if it's used as an alter ego, it's very easy for the courts to pierce the corporate veil and reach the members if the members do not act appropriately or do not maintain the formalities of an LLC, which means filing your annual statements, maintaining separate bank accounts, having employees. All those items have to be satisfied. You cannot commingle funds with the company funds, and you cannot use the company assets for your personal gains or uses. So that's what a limited liability company is. But if there are more than 2 or 3 members, then that corporate veil can be maintained by following your protocols that are associated with the limited liability company. And most of the time, your operating agreement lays out these protocols. Operating agreement for limited liability companies are usually less costly than an S Corp or a C Corp. So I'm going to jump to the next slide, which is the S Corp. S Corp can be formed by a single owner, shareholder, and because it's an S Corp, it's going to be mostly shareholders, and the shares are what are issued. The only drawback to an S Corp is you cannot have any non-resident alien owners. What that means is if you are trying to attract any funds internationally or are looking at any VCs that are international VCs, you cannot take those funds. So basically, it cuts those people off from investing in your company. So that's one of the drawbacks of having an S Corp. The other drawback of having an S Corp is you cannot have more than 100 owners. Is if you recall, in a LLC, you could have as many owners as you want, but in an S Corp, you cannot have more than 100 owners. As far as formalities are concerned, you have to do annual filings, you have to have a registered agent, you have to adopt bylaws, you have to issue stock, hold initial and annual director and shareholder meetings, keep minutes of those meetings, and you need a business license like the other entities. The other drawback of such entity is because once you get more complicated and business takes off, you try to have multiple entities within the parent company. However, an S Corp cannot be owned by a corporation, LLC, or partnership. So that pretty much limits who the owners are. The bylaws of a S Corp dictate the operation of the S Corp. Distributions are based on the ownership. Remember, in the LLC, you could own 60% or 70% of the membership interest, but you could also pay out about 70% of your profits or 80% of your profits to your investors. In an S Corp, you cannot do that. If you own 50% of the S Corp, you will only get 50% of the profit or the losses. You cannot change those things. As a result of that, you cannot have different classes of stock. Remember, in the LLC, we said that there can be different membership interests, but in an S Corp, you cannot have those different classes with different financial rights. So everybody is equal here. The benefit of having an S Corp is that under the LLC, everybody gets taxed on whatever income is generated by the LLC. Over here, what happens is you can actually, the officers can actually be put on a payroll, and that pay is subject to the self-employment and tax, and each owner can be treated as an employee, and then the remaining funds that are generated are just generally taxed. So that's one way of looking at this as a benefit because it can reduce your taxes if used properly. There's a restriction on how you transfer the stocks. And the issue with that is because of the ineligible shareholders, which are the international shareholders, you have to be very careful who buys the stock because this can create a lot of liability for the company if you have owners that are non-resident owners in the S corp. As other entities, this is a separate legal entity. It's a pass-through to each owner. Again, goes through your K1s. May have self-employment tax as the owner can be treated as an employee. There is no double taxation in here. And I'll talk about it in the next section, which is the corporation, what double taxation is. And there is limited liability protection in it. And you have to maintain all the formalities of what's required from an S corp. So the last one that's more important and the one that most investors like is the C corporation. You need shareholders to form a corporation. They can be multiple owners. There's no restriction on how many owners there can be. It's created through a state filing. You need a registered agent. Formation documents are required. Articles of incorporation. You have to have stock issuance, annual reports, keep meeting minutes, adopting bylaws, and you need a business license. The bylaws basically dictate how the corporation is going to act, how the board is going to oversee, and what are the job descriptions of the officers, which are also elected by the board. You can have multiple classes of stock. So you can have preferred stock, you can have basic stock, which is the common stock, and you can build upon those classes. So suppose you have class A, class B, class C stocks, so you can have different stocks and you can structure it differently. There is no ownership restriction. You can buy and sell the corporation because there is no restriction on who can own the shares. Plus, the C corporation, you can go public. S corp, you cannot go public with. This is a separate legal entity. What happens is because it's a separate legal entity, it gets taxed on the income it generates, and then when it distributes that income to its stockholders, that income gets taxed again on those shareholders' personal tax return as income. So that's where the double taxation comes into place. Apart from that, you have the limited liability protection over here as well. You only lose up to the funds that you have invested in the corporation. Nothing comes back to you at the end of the day if something goes wrong. They will look at the officers and the directors of the corporation to see where things went wrong. So those are the entities that I want to talk to you about and introduce those entities to you. Any questions at this point?
I have a question.
Please.
Thank you. So can you define overseeing things?
As far as, sorry?
Oversight.
Oversight of what?
Board oversight of the operations of the company.
Okay, board oversight of the operation means board basically determines what steps need to be taken and how the corporation is going to move forward, and whether the officers are in line with the vision of the board members. That's the oversight that the board provides.
Okay, but they're not doing day-to-day operations or process.
No, the day-to-day operations are with the officers of the corporation, not the board members. They are the big picture people, and the officers and the employees are the day-to-day people.
Okay, and then we have a question in chat about your contact information in case they would like to get in touch with you.
Could you drop that in the chat, Omar?
I can drop that in the chat.
Thank you. You can do it when you're done with your presentation.
No, that's fine. I can do that. That's not a problem.
I had
Any additional questions?
Yeah, I had a quick question.
Please.
Can the S corp own the C corp?
Can the S corp own a C corp?
Yes. Or does it have to be like a natural person that owns the corporation?
Not necessarily. The S corp can own C corp stock. Anybody can own a C corp stock.
And then if you were to raise money from an international investor, if you were an S corp, is there any way like through Cayman Islands, anything like that, that they would be able to invest in your entity that way? Or is that, I don't want to get
Again,
too far into the weeds with that one.
again, it's all international. As long as it's international owners, you cannot go into an S corp.
I'm just trying to figure out who you know in the Cayman Islands, Brandon.
And if you're going to do something like that, please don't let me know.
No, I was thinking about because I used to work for a company. They raised international money through international entities, but I believe um, they filed in I believe Delaware.
It doesn't matter where you are. It's as long as it's S corp, you cannot. This is federal rules that you cannot have any non-alien, what do you call it?
Non-resident.
Non-resident aliens as owners. It could be
Gotcha.
corporations, whatever it is. As long as it's non-resident, you cannot do that.
Sure. Right.
But if it's an LLC, yes, you can. There's no issues with an LLC, and there's no issues with a C corp.
We have one more question from Michelle. Is it best to fundraise on a safe note?
I think so. I'm kind of in like the real estate space. I was just curious about, raising those initial funds for like, let's say, if I wanted to purchase like a portfolio, would it be best, I guess, to structure it as a GP LP situation where, obviously we raise the money through the limited partner, the GP will be the operator. And then is the bank involved in that? So let's say it was a multi-unit building, could they come in at some point? Would they be on the LP side or?
They won't come on the LP side. They will come on the GP side because they want the GP to guarantee the note. Again, remember, a limited partner only has limited liability up to the investment into the company. So they will want to have a general partner guarantee the note. Banks usually have little apprehension on LLCs, lending on LLCs, unless they have a warm body to guarantee that note.
Any more questions?
Hi, I actually have a question. I'm a massage therapist by trade, and I've operated under sole proprietorship, and had to file my Schedule C every year for the past decade. But I'm now in a situation where I'm going to be leasing space and kind of branching out into like a beauty spa situation. Would you think would it be wise to remain a sole proprietorship and include those funds, or should I be branching out and maybe leveling up to an LLC?
It all depends, and the reason why I say it depends is when you're branching out, are you going to have any employees?
No, it's still going to be me doing everything.
So remember when I spoke about that, it's a misnomer basically when they say that limited liability protection applies to you. Because when you're a individual owner, a single owner, single member LLC, what happens is the LLC becomes an alter ego of you. So whatever you do is still going to be you at the end of the day. Because if you go through the LLC, if something goes wrong, the corporate veil is going to be easily pierced. And at the end of the day, they're going to come directly at you. And because you're the manager and also the operator at that point, there's no protection for you. So if you want to, if you're not going to have any employees, I would recommend just stay the way you are, because your liability is not going to be restricted by any of these things. The only thing is going to be you're going to have an added expense of renewing and filing your corporate documents every year.
And honestly, it's actually good news, because now I don't have to worry about doing that and spending those extra funds. Thank you.
Good, thanks.
Hi, good afternoon. So in my case, I would be leaning towards the employee situation. I have a cheesecake company that I would eventually like to create a dessert lounge around. And at that point, I would have to have employees and that sort of thing. So in my situation, it would be probably best to have it as a corporation, or what would be your opinion on that?
So, Lawrence, there's a couple options. So one of the options is that what is this called? Um, you start off as an LLC
Mhm.
and then you convert it into an S corp. But you can I mean, it all depends on how much money you're starting to make. If you're making a lot of money, then I would recommend going directly into an S corp. Okay, because what you can do is you can have employees in the S corp. You can get your income to be taxed, pay the self-employment tax and all that stuff on that income, and whatever this income is, you just pay the general tax, not all the self-employment tax off that. But the caveat for the S corp is that the income that you take or you pay yourself through the S corp has to be equivalent to what's in the market of that. If it doesn't match the market, then IRS can have a heartburn on what you're doing with that. If it's less than the market, they can come and look at you and say, you know, why aren't you getting paid? Or if you're putting all the income through the LLC, through the S corp, they're going to have a heartburn on that, because now all of a sudden you're doing is basically putting all your income through that, employee, instead of doing it yourself. Instead of declaring that income separately. So they can have a heartburn on that.
Also, Omar and Rakshana would like cheesecake for his advice.
You got it. Thank you.
Any
Hey,
other?
kind of building-
Sorry, John, go ahead.
Yeah, absolutely. So kind of building upon that last one. So right now, my organization, Deeds Enterprises LLC, is a Nevada LLC. It is a single entity, disregard entity LLC. So are there any pitfalls that I need to know? I want to make sure that I'm absolutely rock solid come, for the 2023 tax year and everything. Are there any particular pitfalls I need to be cognizant of as I wrap up these last several months of the tax year?
I'm not a tax attorney, so I can't give you advice on that part. But all I will say is, as long as you have maintained the protocols of the LLC, you should be fine, and there should be no issues. If you have issues regarding having to pay too much tax, or are you worried about that, I would recommend we consult a tax attorney or an accountant for that. Okay, if you don't know anybody, let me know. I can introduce you to some people. I know we have people in our firm that are tax attorneys that specialize in that kind of stuff.
Very good. Thank you.
We have a question online from Magdalene, who is asking, is there a difference between an LLC and a professional LLC?
Again, the PLLC is similar to a professional LLC is usually reserved for professionals like, again, doctors, attorneys, those kind of things. And that's where it comes into play. It's specific. It has more rules and regulations than a regular LLC, more requirements. So if you are not in that field, I would recommend not touching the professional LLC, PLLC.
Okay. Any more questions for Omar?
I just had one about the share. So, to issue shares, of it like a single asset class, let's say for myself, if I had an S corp, would I need like obviously separate paperwork to say, hey, these are the, preferred shares for, my company LLC, and then I just
Yes,
file those away?
there are separate offering memorandums that you will have when you file. You're going to let the state know how many shares are out there. And based on those shares, you're gonna have a separate memorandum of offering and acceptance that you're gonna keep with your corporate documents.
All right, sorry, piggyback off of that. Is there like a par value to give those, or is it just kind of, you know,
Whatever you want it to be. But just keep in mind that whenever you form an LLC or an S corp or something, make sure that it's funded properly. If it's not funded properly, then what happens is it again exposes you to be liable for the liability of the company because you have underfunded the LLC and you never had the intent of using the LLC as it was supposed to be used. So that really, I mean, courts look at that when if there's malpractice by any of the directors, managers, anything like that, they want to look at that as to see what happened and why was the company not funded properly. If it wasn't funded properly, then that's easier for them to pierce a corporate veil and reach to you and your personal assets.
Okay. If we don't have any more questions, and Omar, if you have nothing else to add, do you want to close or?
I do have one quick question.
Oh, Roberto.
Yes. How are you doing? Thank you for your time, Omar. The question is, you didn't talk about it, probably not relevant, but I was told to open up a series LLC. And that's for, I've got 4 rental properties, and I was told to put each one of them, all 4 of them into this series LLC. Someone else mentioned it's best to keep them individual LLC corporations by themselves. What do you recommend?
So a series LLC is great on saving filings because what you can do is put each property under a separate LLC. Just you got to keep in mind the series LLC is only recognized in certain states. Nevada is one of those states. California does not recognize it. So if you try to buy a property in California and use the series and everything, the California is going to disregard the series and consider it as an LLC. But if you're keeping your properties within Nevada, yes, you should use series, and each series is treated separately as a separate entity.
Okay, thank you. And just to add to that, I did ask, I deal with Bank of America, and they mentioned that they don't open series LLC bank accounts because they don't like their structures. Does that make sense?
Yes, each bank has its own preferences. There are a lot of banks in town that are open to series LLCs, and there are a lot of banks in town that will lend on separate series without having the other series to guarantee that specific series.
Okay, thank you. And just one last thing to add in regards to that series LLC. Rental income coming in from those properties going into that one account, is that commingling funds? And if something goes wrong with one of the properties, can now they come after me for
Yes.
if something slips? Okay, so
Yes.
if that's true, then it would be best to just keep them in separate LLCs. What's the best way?
So what happens in the series LLC is each series can have its own tax ID number.
Oh.
Okay. So what you can do is open an account for each separate series. And you treat that series separately. So traditionally, why people use series is what I've seen with my investors is that there is one manager that is the main manager for the main series. And then he brings in investors for each series and buys properties for each series. So every series has a separate ownership structure. So if what you were saying was, if it was just one account, then that would be commingling of funds of all of that and everything is the same, right? It doesn't make sense. But because the series provides the opportunity to set up separate accounts under separate EIN numbers, that's why it's so beneficial. Because you can have one manager, or you can even change the managers, on each series. And you can have a different composition of owners in that series, as long as the main person from the main series is part of all those series.
Thank you very much. I appreciate that. That's helpful.
One more question. Can an LLC from another state, Florida, operate here in Nevada? Should I create a new LLC here or can it be transferred to Nevada?
As long as it's in good standings in Florida, you can file that over here as a foreign entity doing business in Nevada.
Jennifer mentioned just a quick note to the team. Clark County Credit Union was helpful when I opened my Series LLC, but they do not have all the major bank-like, I'm assuming benefits of Bank of America. So just putting that out there. Thank you, Jennifer, for that. Okay.
Well, thank you everybody for your time. I appreciate it. If you guys have any questions, I put my contact information in there. Just send it to me and I will be more than happy to answer your questions.
Thanks, Omar.
Thank you.
Lawrence will be sending you cheesecake, so don't worry.
Excellent.
Our next speaker, James, is very familiar with Startup Envy. He's spoken more than a few times. So welcome back, James. Thank you for coming. So a bit of background about James, a patent attorney with over 30 years of intellectual property experience. He has provided legal services to individuals, startups, and large companies, IP, trademarks, and copyrights. Not licensed in Nevada, is licensed in Michigan. So James, if you want to take it away.
So yes, my name is James G. I do go by Jim. I did put my contact information in the messaging slot. I do have, funny thing about experience, it does seem to go up every year. So now I'm looking at 35 years of experience. I am based here or work remotely here in Las Vegas. The firm is based in Michigan, and I'm also licensed in Illinois, as well as before the U.S. Patent and Trademark Office. So today we're going to talk about, we're going to go briefly talk about the different types of intellectual property. We're going to talk about a few pitfalls that hopefully you know startups face and can avoid relatively easily. We're going to talk a little bit about choosing a name. We're going to run through a little hypothetical about a startup company and how they can use intellectual property. And then we're going to answer any questions. So I'm going to apologize, I'm going to run through some of these slides relatively quickly. This is just a summary of my background. Some of the clients that I've represented over the years. I've been in Vegas for close to 14 years, and I've done a lot of casino gaming work. Some of the technology I've worked on, and some of the patents that I've worked on through here. This is a patent that was assigned to a startup out of North Carolina called PokerTech, and they developed a series of electronic poker tables. They went public a number of years ago, and then they were bought out by Multimedia Games, which is based in Austin, Texas. This is another gaming patent that was originally assigned to a company called Streamline, and those patents were bought by Shufflemaster, which is now part of Light & Wonder. So just some more recent ones. All right. Again, I'm sorry, we're gonna run through these pretty quickly, but if you have any questions, you can ask me during or later. So we're gonna talk about trademarks, copyrights, patents, and trade secrets a little bit. All right. So what is a trademark? Well, a trademark is a word or design that customers uniquely associate with a particular source of goods or services. So either the company name or a brand name. And when you have trademark rights, it gives you the ability to prevent other companies or people from marking or selling goods, similar goods, with the same or the similar mark. What it doesn't mean is that others can use the mark referencing your goods in a truthful manner. So if they're, for example, talking about your products within an article in a newspaper or a magazine, they can obviously use your mark. Or if they're using it in advertising to compare their own goods or services with yours, as long as they do that in a truthful manner, they can use your mark in that way. So from a startup, you may be, when you're starting a company, or you may be looking at, developing a name for your company or a brand name for your goods. And when you're looking at potential marks and you're looking for protection, the potential marks are going to maybe characterized in one of these categories. All right. Now, these categories are not definitely or clearly defined, so there might be some overlap. It's just kind of a ranking of where your potential name may fall. In this list, we start at generic, and then we end up down at fanciful. And when you start using a mark as a trademark, generic or descriptive names are not going to be very strong, right? A generic word is something that describes exactly what you're selling. For example, if you live by a lake and you want to open a bait shop and you call it bait shop, well, that's a generic word for exactly what you're selling, and it's not a very strong mark. And so there's not really a lot of thing that you can do if somebody wants to open up a bait shop right next to you. All right. So as you get down that list, the stronger the potential mark can be. All right. So the strongest marks are going to be arbitrary or fanciful. So you can think of an arbitrary mark as maybe a real word, but that is not really related to the goods or services that you're going to offer. Probably one of the most famous ones is Apple, right? Apple sells computers, tablets, phones. None of that is necessarily related to the word Apple, but it's obviously now a strong mark, and that's an arbitrary. A fanciful mark you can think of as like a made-up word that really has no meaning. This mark, PZGEQ, is actually a federally registered mark, but it has actually no real meaning. And the other thing that we have to be careful about is when you're thinking about a name is, while it may be a made-up word to you, you might also want to consider looking at whether or not it has some meaning in another language. And you don't want to make a mistake about calling it something offensive or descriptive, or that means something that you didn't intend to in another language. We'll also have to be careful about when you start using a name, is that you have to police the mark to make sure that it doesn't become generic. And what that means is it doesn't become synonymous with the goods that you're selling it. So these are all names that were originally trademarks and have over time, at least in the US, lost their trademark status and now are generic for the product that they were originally used with. All right, let me go back here for a second. And so a lot of companies, when they have strong trademarks portfolio, they'll have one or two people that are just there to monitor literature and their competitors to make sure that they're using their marks correctly. And if they're not, they'll send out a cease and desist letter to tell them to stop doing it and use it correctly. All right. What is a copyright and what does it protect? Well, copyrights protect original works of authorship. For example, novels, plays, songs, software, photographs. And it gives the copyright holder the exclusive right to make a copy of that protected work or to modify that work. And one thing that we got to note is that it requires copying for infringement. So just the fact that a particular piece of work or another piece of work has similar aspects to it, that could be coincidental. If there hasn't been copying, then there's not copyright infringement. Trade secret. So a trade secret really is any information that is secret. It can be, for example, formulas, compositions, method of manufacture. I think probably the most famous one or two is going to be KFC's blend of spices, Coca-Cola formula. Those are trade secrets. But you must take, the owner of the trade secret must take steps to keep it secret. They just can't say, put it out there and say, hey, we intend to keep this a trade secret, if they don't put any steps in to actually keep it secret. There are some benefits to trade secrets. One, it could potentially last forever. As long as it's kept secret, then the protection lasts forever. But what it does only protect from, it only protects from theft. Somebody gets obtains it illegally or through some subterfuge. There's no subject matter restriction on it, but it doesn't protect from another company independently developing something similar or finding out the formula by themselves or reverse engineering. So if you put out a product and there's something in there that you think is trade secret, if somebody can take that product, buy the product, reverse engineer and find it, and that's not a violation of the trade secret, and so therefore it might not be worth, it might not be subject to trade secret protection if somebody can reverse engineer. So now we turn to patents. So what is a patent? A patent is really a grant from the government to the inventor or the owner of the technology, and it gives them a limited monopoly in time to prevent other people from practicing the invention. So it's really resulting from a bargain between the government and the inventor. So the government is giving the patentee or the inventor this limited monopoly, but it's also requires the inventor to tell everybody what they're doing and how to do it in the patent application itself. The rights of the patent protection are defined by the claims, and we'll talk a little bit about that in a second. But again, it gives you the right, the patentee, the right to exclude others from making, using, selling, offering to sell, or importing the protected technology. The length of the protection is there's a couple different types of patents. A utility patent is 20 years from the first filing date, and the design patent is 15 years from the issue date. So they're a little bit different there. What can be patented? Well, you can patent a process, a machine, an article of manufacture, or a composition of matter. And it must meet these three requirements. One, it must be useful, it must be new or novel, and it must be non-obvious. Most things are going to be useful. That's not a standard that's hard to meet. The other two, novel and non-obvious, those are going to be judged by what we call the prior art. Prior art you can think of as any public knowledge that is available prior to your filing your patent application. And so it can be other patent documents, it can be products that are on the marketplace, it can be stuff that was talked about in trade journals or articles in magazines, or even just stuff that was disclosed or talked about at a trade show. And basically novel means it is that whatever you're trying to get a patent on, it can't be have been disclosed or shown in a single piece of prior art. For something to be non-obvious, the elements of that claim, of the patent claim, can't be shown in two or more pieces of prior art where there's some motivation to combine those pieces of prior art. And as you may know, when you file a patent application, it goes through an examination process at the patent office in front of a patent examiner who has a science or engineering background that's going to be relevant to the technology. Again, there are different types of patents. A utility patent protects how things function or the elements that are in a combination are required for the product to work. A design patent only protects the aesthetic elements, the way something looks. Think of like a bottle, like a Coke bottle or something. And a plant patent, which I have literally no experience on, protects new and distinct varieties of plants. All right. So I'm sorry I just ran through that really quickly. I'm just going to run through a couple of hints or potential pitfalls and what you need to think about when you're starting your company or starting up a new product. The first thing is to secure the ownership of all the IP. Now, I think I mentioned that IP, for example, patented technology or technology that is subject to patent has creators. Those are called inventors when you talk about patents. Initially, ownership resides in inventors, and it must be transferred over to another person or to the company that wants ownership of it. Typically, if the technology is developed by employees, there's going to be an employee agreement that automatically transfers that over to the company. But there's other ways that technology can get to a company. One, what Omar was talking about, founders, or when you create an entity, one of the owners or one of the founders of the company can bring technology into the company, and that needs to be, if the company is going to use it, it needs to somehow either through a license or be owned by the company. And that can be done at startup or the operating agreement or when you're forming a company. The other way that it comes up is, which can be really tricky, is when you're starting up the company and you're working on developing the product and you need some assistance on it. Maybe you have a friend, or maybe you have an acquaintance or a friend of an acquaintance that's going to help you to develop or move forward the technology. Sometimes that person may not get paid, or sometimes you just may pay them, some cash or maybe even a purchase order. Well, that doesn't necessarily mean that the ownership of the IP is going to transfer over to your company. So you want to have an agreement with that third party if they're going to help you to make sure that the ownership gets transferred over. And it has to be in writing and it has to be signed. So I'm just going to run through a very, very quick hypothetical. I'll give some examples. I have some examples of some patents, and we'll talk a little bit about that. But let's say that you have an inventor. He invents or designs 2 new chairs, and he wants to start a company to sell those chairs online or in the store. And he needs a third party to complete the design to get it ready for manufacture. All right, that could be a design house, an engineering source, or it could be actually, some manufacturer that he hires. So we're going to talk a little bit about, how that company can use trademark or design or utility patent protection, or where copyright or trade secret may come up.
James, we have one question. What is the difference between a utility patent and a design patent?
Okay, we'll explain that a little bit in a second, but and I do have examples of a utility and a design on a chair that we're going to talk about, but design only protects the way something looks, non-functional. So if you have a Coca-Cola bottle, the way that looks, it allows you to prevent other people from selling a bottle that looks very similar to that. So the standard is, would a consumer be confused that this bottle is a Coke bottle versus some other company's bottle? All right. So we'll talk a little bit about that. I have an example. A utility is doesn't cover how it looks, but what are the elements that make it function. And it doesn't have to look like it. And I do have an example here in a second. Okay.
Thank you.
All right. Okay. So just talking briefly, if you're starting up a new company and you want to choose a name, this company is going to be selling chairs. So something like the chair company, that's generic. That's telling you exactly what you're going to be selling. The chair that we're going to talk about has an adjustable seat. So, obviously the chair company, generic, that's not a very strong name. I get a lot of clients wanting to use a very generic or a very descriptive name, and I try to convince them to go to something that's a little bit more arbitrary, just because it's going to be, they're going to, once they get a reputation and that mark has some goodwill associated with it, it's going to be a much stronger mark in terms of them being able to prevent other companies from using something similar. So I just threw out some names here. The Bait Chair Company. Obviously, bait has nothing to do with chairs, so that's an arbitrary name. And then I just threw some letters in to create a new word, and that's a fanciful name. That's going to be, once you get some goodwill associated with either of these latter two, those are going to be relatively strong marks. Once you choose a name, you want to do a search. There's a federal register of federally registered marks that you can search really easily. And you can also do an internet search to see if anybody's using that same name in relation to chairs in any way. And the reason that you want to do that is because you don't want to invest your time and your money into that name, whether it's in packaging or advertising. And 6 months later, you get a cease and desist letter that somebody says, hey, I'm using that same name to sell chairs, and you got to stop using it. And now you got to go back and change everything and waste your money. And once you've gone through those, you can immediately start using the name. If you see a trademark or a name that has a TM, that just means somebody is using the name or that word as a trademark, and they may be accruing some rights into it, and the kind of puts you on notice. You can also file a federal registration, which goes through an examination process, and then once that's been examined and found to be worthy of trademark protection, you eventually get a registration, and that gives you protection across the U.S. All right. So again, we talked about this before. If you have an employee that's helping develop or finish the design of these chairs or your products, you want to make sure you have an employee agreement that transfers ownership of any IP that they generate to your company. And certainly if you're using a third party to finalize the design for manufacturing, you need a signed agreement to transfer that IP over to your company. And if you're interested in seeking patent protection, I would advise you to seek advice from a patent attorney. There are some pitfalls that you wanna avoid. The U.S., like most of the world, is what's called a first to file system. So what that means is that the earlier, as I mentioned before, the prior art that can be used against your patent application is going to be defined by your filing date. So the earlier the filing date you have, potentially the more prior art that you're going to cut off. The other thing you got to be careful of is once you begin selling or publicly disclosing your product, then if you're outside of the US, that immediately becomes prior art, and it can restrict you or bar you from getting patent protection outside the US. In the US, we have what's called a 1-year grace period. So if you disclose your invention or you start selling it, you have 1 year in which to seek protection. So these are just some kind of the pitfalls you need to be aware about. Let's see. Okay, so I threw up a couple or looked at a couple patents. This first one that are related to chairs. This one is from 2008, and it's a design patent on this chair and on this particular chair. And basically, what a design patent consists of is mostly figures. And the claim of a design patent is going to say something along the lines of, we claim or we invented a chair as per the drawings. So there's going to be a number of views of the drawings. Of the chair, different views. And really what it protects is it allows you to prevent other people from selling a chair that looks like this chair. And the standard for infringement is whether or not a consumer is going to be confused as to whether the chair sold by this other company was sourced by you, whether it's your chair. So that's what a design patent is. Now let's switch to a utility. And this one's even older. This is from 1899. But the reason I chose this is because it has a very, very simple claim that we can put up here. All right. So a patent application or a patent is going to have a series of drawings that show the invention, and it's going to have a written description to describe all the elements and how they work together. But then it's going to have a set of claims to define what's protected by that patent. And this is here on the left. This is the patent, or this is the claim from that patent. And that claim is directed towards a chair that includes a frame, an independent tilting seat, and we can see it here in blue, a pair of supporting blocks in green. They are fastened to the bottom of that seat, and they sit within the supporting rests. So the blocks are in green and the supporting rest is in yellow. And it just sits in there and allows the chair to rotate in the direction of this arrow. So somebody asked about what the difference between a design and a utility patent. Obviously, these are two different chairs, but this chair protects from anybody. It gives you the right to exclude anybody from practicing a chair that looks like this. And now that chair might tilt or might have some other features about how it operates, or it might not. But that's immaterial from a design patent standpoint. It's just the way it looks. This one, for infringement of the utility patent, we don't care how it looks. What we care about is these elements on the claim. So any chair during the term of this patent, any chair that is sold that has these elements the patentee could prevent them or exclude them from selling. And what that means is they could either stop them from selling the device or the chair, or they could seek a royalty for them. Okay, for this new company, these are the type of things that could be protected by copyright. Any marketing materials, their website, pictures that are used in the promotion or their advertising. Maybe they created some software to run their e-business or to run something on something at the office, and the prints for manufacturing. Those could all be protected by copyright. You could also have some things that potentially could be protected by trade secrets. And again, these are stuff that you would have to keep secret and that would not be reverse engineered. So, it could be composition of some of the chair components, but that composition could be reverse engineered if somebody had one of the chairs, and by doing a breakdown, then it might not be protected by trade secret. That's really all I had to talk about. I tried to give just a really, really broad overview of the different types of IP and how they could be used in a startup. So are there any questions?
David Navarro has an ergonomic chair patent, and this is hitting close to home for him. It looks like Brandon might have a question. Brandon?
Yeah, I had a quick question. So if I was and as you were speaking, I was trying to write it down. You touched on it with the copyright, but I'll try to kind of read what I wrote, see if it makes sense. So if I was to create like an app platform using some existing processes that were already maybe protected by someone else, and probably just answer the question, maybe get a license, right? But what's protectable in that scenario for my usage if I'm using it for my business? I don't know if you would need me to like restate it.
You've written an app or a piece of software that you want to use in your business.
Yeah, hypothetically. I'm not a software engineer, but I would hire someone to do that.
Yeah, sure.
Yeah.
Sure. Okay. So I think there's two sides to that. Is are you infringing somebody else's copyright or something like that? Is that first part of it?
I think that's where it's gray. The use would be, it's really like, let's say a ride hailing, like a ride share
Sure. Yeah,
type of system.
Okay.
But let's say creating my own, and I think the question was, is that utility as well as copyright, or copyright or utility, or?
Sure.
Mm.
Yeah, software can be, these are not necessarily these type of IPs in their own little silos. There can be some overlap. So certainly copyright, the copyright on software, and that software could be part of something that could be patently or protected by a utility patent, right? So they're not, necessarily mutually exclusive. So from if I divide your question in two parts, right? So if you hire somebody to write the code, or you write the code yourself, that code it may be protected by copyright, right? And the problem becomes, right, is if the software writer, drafter, writer writes everything from scratch, okay, then the copyright initially is his or hers as the author, and then you would need to transfer it to you. Okay. Now there comes two problems. Most modern software, they're going to use libraries from other companies, libraries of software code, right? So they'll have to do is to make sure that they have the license, and that's what what that software code is for. So they may go to Microsoft or Google or whatever and get some software libraries and that are designed for this to perform specific functions that you're going to use and he's going to use in the code that he gives to you. As long as he has a license that he can use that in that way, then you're fine. There's that's what it's for, right? He's paying for that license so that he can use those libraries and to write code and give it to you. Part of the problem could be that if you go into somewhere else, is that he doesn't have the right licenses in order for him to, give it to you to use commercially. So you, in your contract with him, have to make sure that he warranties that he does have it. He has that ability to incorporate that code and give it to you and so forth. The other potential problem is that if his business is writing software code, is two issues. One is he's got his own library of code that he's going to reuse for whatever, for multiple customers. So you need to make sure that you have the right, as long that when he gives it to you, that he's giving you a license to use that code. The other potential problem is that he's going to use code that he sold to somebody else. So he doesn't own the copyright. You also have to, in your agreement with him, is to warranty against that. There are a lot of potential downsides to, or traps that you need to look out for when you're having somebody draft code.
Okay, and if he was to write it from scratch, would there be any, if it was similar to another product, would there be any unique claims that I could make? Okay.
Yeah, so that's, it's a good question. We call that a clean room. So if I was concerned about that, a lot of times when it comes to software code, what the problem arises when coders change jobs, and they might have a tendency to take code with them that they use with their former employer with their new employee, right? So if I ever have a client that says, hey, I want to write a piece of software that does this, but and it's similar to one of their employees' former employers, what I would tell him is, I would advise that client is to use a clean room. Don't use that coder, use somebody else, and make sure that they're in a clean room and have no access to that software.
We have one question online, James. What is the bargain federal government and innovation?
What is the what?
The bargain federal government and innovation. Gabrielle, if you want to unmute yourself, maybe you can add a bit of context to your question.
So he was showing that under the patent trade secret, it was one of the exclusive grant innovation bargain federal government and innovation. So I was just asking what is that?
So the bargain between the federal government on the patent side?
Yeah.
Okay. So basically what that means is what that means is the government is giving you this limit when you get a patent. The government is giving you a limited monopoly for a number of years to gives you the ability to exclude other people from practicing. The bargain is in that, in the utility application mostly is you have to provide enough information in that patent document to allow for other people to practice the invention. You're basically telling them how to do it. That's the bargain. In exchange for you giving up this information and put it in your patent document, the government's going to give you a limited monopoly. That's the bargain. That's the exchange.
So is this something that the government gives me or I get on my own?
Well, when you file a patent application, then you have to include that information. And then it goes through an examination process to determine whether or not you've defined something in your claims to be different enough from the prior art. And if the patent office, through an examiner, determines that, yeah, you have something patentable here, then they give you then you get an issued patent, and that's what they give to you.
So it would be similar like how you showed with the chair, the different breakdowns of the chair. And like if you added something different, like descriptive, like let's say it was a regular chair, and then you add that like an arm can move left or right or something like that. That would be
as long as whatever you define.
Scenario of that.
Right. So as long as whatever new feature you've added to the chair is different enough based on those standards I talked about earlier, then all the other chairs that existed before you filed, then you can get a patent on it. But and the government is giving you that limited monopoly when they issue the patent, but you're telling them how to practice your invention. It's no longer secret. It's in the document. It's in the patent document. That's the bargain. That's the exchange.
One more question.
Sure.
So how hard or easy is it to defend software patents? There's more than one way to skin a cat with software, so is it even worth going through the patent process?
I hate this question. Software patents are hard. Software patents, and what I mean by software patents are where you have an invention or technology that is embodied solely in the software. I've gotten patents. I continue to get patents that are embodied solely in software. But I would be hesitant to tell anybody to go ahead and assert that patent against, Google, Microsoft, Apple. They are just going to overwhelm you, and it's going to be very, very expensive. Why would you get a software patent? Well, you can use the software patent to seek investors. If you watch any of any of the shows that or any of these competitions about pitches and stuff, they typically will ask you what your patent position is. It can be for seeking investors. It can, issued patents can be used as collateral for loans. Issued patents can be used as defensive publications or defensive. So if you're out there running a business and you have a competitor that has patents and they assert a patent against you, well, you have something to assert back and potentially cross license. But I would, in today's environment, I would be hesitant to sue somebody on a pure software patent.
Killed my dreams, James. Killed my dreams. No, I'm just kidding.
Yeah, well, it's the unfortunate, I've been doing this for 35 years and I've done a lot of software, and the pendulum has swung back and forth numerous times on software patents. About 12 years ago, there was a Supreme Court case called Alice that threw it all up in the air. And unfortunately, the pendulum has not swung back yet.
Interesting.
I have one last question. So let's say you had an autonomous vehicle company and I have a real estate software company and I wanted to merge the two together. Okay. How would that work? Is it a license? Is it a patent? Is it something we would need to create something totally different? Trying to figure that out.
I'm not sure. Are you talking about merging the companies together, or how would you do?
Just more of I guess a partnership, essentially, like a strategic partnership. But you already have the technology. You've been working on it for years. I have technology, and I just want to merge basically the two environments together, to create something totally new.
Yeah,
essentially.
I mean, I think you would need a little bit more information in what the new business is going to look like, who's going to run it. But it could be done. It could be done, a number of ways. You could create a holding company and put all the intellectual property in the holding company and have one company license the IP from the other one. I don't know if you're going to create one parent company for two entities. It really depends on how I think, Omar may be able to weigh in on this, but it really depends on how you're going to run the company and how you're going to set that up. It can be all the IP could be owned by one company, or one company could license, whatever necessary IP to the other company. It really depends on, how you're going to run the company, I think.
So I have had a situation where one company, the gentleman basically joined a partnership, and he was the one who invented this program or software. And what he did was he put the software in one company and then rented that software out to the other company. That was one way of doing it.
Okay, thank you.
Yeah, I think that's particular if the owner of that IP is not necessarily going to be too much involved in the new company, right? So the only thing they're contributing or they own is this technology, and maybe the best thing for them, if they're not going to be involved, is holding on ownership of the IP and then just licensing it to the other company or to a new company. But if they're going to have, it really depends. If they're going to be, if they're going to be involved in this new company or this new entity, however it goes forward, that could be their contribution, to the startup.
Okay. And that's more like a structure type of question.
I think so.
Okay. Okay. All right. Thank you.
Hello. I'm the one who posted that I already have a patent that's already been done. It's just filed October 3rd, which is exciting. But my question is, I had a guy out of New York who really just insisted that I file continuations, and just per his instruction, I did that. The first question is, how important are those continuations? And then the second question I have, well, I'll let you answer that one first.
I'm sorry, what is your name? I think we met, right?
Yeah, my name's David. I had liability questions for you, but I think this falls more into your expertise.
Okay. All right. So continuations can be very, very important. So if we go, if you look at, can be important for a couple different ways. You have this is a utility application, I'm assuming, right?
Correct.
Okay. So you have this written description of your chair, and then in your application, and then you have the claims, which could be, you're going to have multiple independent claims, multiple dependent claims, and those have, when you write those, or with your patent attorney, the independent claims, you go in there thinking, hey, this is what my invention is, right? And it's going to be a chair, and it has 10 elements in your first independent claim, right? Or however many. And then you go through an examination, and the examiner comes up with a piece of prior art or pieces of prior art and says, your patent claim is not patentable because of this prior art. And so what you do is, with your patent attorney, is you either make your first claims narrower. You're adding elements, or you're narrowing a specific element, right? To overcome that prior art.
Yeah.
Right? Okay. So now you have, your original claim had 10 elements, and now you have 11 elements. And if that patent issues, your first claim has 11 elements. And for somebody to infringe that claim, they have to have all 11 elements. At least one in your first, for example, in your first independent claim 1. If they don't have one of those elements, then they don't infringe, and you can't stop them.
Gotcha.
So one thing that you can do is look at, hey, I had to add this new feature to overcome prior art. This 11th feature, right? Now go back and look at those claims, and that's what I had to do to get it to allowance. Now go back to your claims and say, well, okay, if I focus in on that element I had to add, are there other elements I can take out or kind of abstract and make those more broad? And so if you're able to do that in this continuation, which is a new application, and would theoretically issue as a separate patent, now you have additional protection. Because if let's say that you were able to get rid of elements 2 and 3, but include that new element, right? Now somebody that could avoid your first patent by not having element 2 or 3, but you don't have that element 2 or 3 in your continuation. The idea of a patent is you are putting roadblocks in front of your potential competitors. So if you have now able to claim your invention in a different way where it's maybe narrower in some aspects, but broader in others, and you're leaving less room for your competitor to avoid your patent.
The next day it was money well spent.
And you can do that, at least right now, as long as you have one patent application in your family alive, pending, you can continue to do that. And one way to look at it is not only are you getting this broader protection, but you can also kind of follow along with the industry, right? This is an industry that there's a lot of development going on and more products are coming out all the time, right? So you can kind of follow along and you can see maybe where the industry is going and you can kind of track that. As long as you have some feature that is described in your application as you originally filed it, you can kind of track where the industry is going and maybe try to cover new chairs that are not out yet, but come out 6 months from now.
I think that's the idea, yeah, because it was the way he explained it to me. He said, what we're filing today, and I had to do it before the patent actually filed. We had to file the continuation and then file to like say this is it, and then it all kind of went in clockwork, one behind the other.
Your continuation has to be filed while your first one was pending, so before the issue date.
Thank you. That definitely explains a lot. I just didn't really understand because he's a quick talker. So I was just like, if you think it's for the best, like do it. Like,
yeah, I do it all the time.
and I think that was my takeaway is I tried to write my initial patent myself, which I told you this, I said I might as well have put macaroni and glitter and sent it into the USPTO and said, here it is, So I just don't speak. We all find out we don't speak that language.
Well, I'm glad you don't speak that language.
That's good.
Okay. Well, thank you to our speakers, Omar and James. Oh, wait, John, do you have a question? No? Okay. Got it. Sorry. I hope everybody has a great night. James, Omar, thank you so much. That was incredibly insightful for our group. And I will see everybody next week.